Following Trump's victory in the Electoral College and the popular vote in the presidential election, you must dismiss this case. It's required. Now, the next thing that we'll have will be adjudication of a motion to dismiss. See, the sentencing is slowly getting moved, bumped, and replaced. We're also going to stay proceedings now until the resolution to avoid unnecessary litigation. And if we go to sentencing now, it would not avoid the new immunity question that they intend to raise. So he finally said the word sentencing. Trump's team declares victory in New York. Alvin Bragg and Judge Merchan having a rough time dealing with the presidential victory, saying that they have beaten the Manhattan witch hunt case, calling this a total and definitive victory for President Trump and the American people who elected him in a landslide, because what has happened is the prosecution has agreed that there should be a pause. They say the Manhattan DA has conceded that this witch hunt cannot continue. The lawless case is now stayed, and President Trump's legal team is moving to get it dismissed once and for all. Stephen Chung, Trump communications director, who's making his way over with the campaign into the administration, and we're excited about that. So they're telling us that the sentencing has been stayed. Some are pointing to this note, including Anna Bauer, and saying that the sentencing has been adjourned into November 26th. So we'll see if that date is still continuing to be held. 9 a.m. We know that the prior sentencing was adjourned, and so we're asking if the 26th date is going to still be on the calendar, but we do not know the answer to that quite yet. But this is what has led to this pause. This is why Trump's team is declaring victory. So let's start with the actual original filing from Trump's defense, which we're just learning about here today because it was attached as Exhibit 1 to the government's response to this. So this is what Trump is asking for. They say, all right, Alvin Bragg. They sent this to Alvin Bragg, right? Not to the judge. They're sending this to the prosecutors. We haven't seen this yet. On behalf of our client, President Trump, Alvin, we respectfully request that you dismiss this case with prejudice and consent to a stay of all deadlines in the case while you consider this request during the pendency of the appeal. Saying the DOJ is reportedly preparing to dismiss these other cases. This is the case in New York State Court. They're going to dismiss the federal cases from Jack Smith, the illegitimate so-called prosecutor. And we were informed by Jack's office last night that they plan to seek a stay of federal deadlines until December 2nd while those deliberations are underway, while they decide, are we going to dismiss this or not? So they write, consistent with those actions, dismissal of this case is necessary under the Constitution and under federal law to facilitate the orderly transition of executive power and in the interest of justice following Trump's victory in the Electoral College and the popular vote in the presidential election. Here's why. You must dismiss this case. It's required. A sitting president may not be prosecuted. Now, in addition to Alvin Bragg's violations of the presidential immunity doctrine during grand jury proceedings and during the trial, which they did flagrantly, it should be dismissed also because now we have new fatal presidential immunity problems now based on Trump's current status and his ongoing official acts in connection with the transition of executive power. They say, stinks to be you, Alvin. Says a sitting president is completely immune from indictment or any criminal process. All right. That comes from the Trump versus United States case and also comes from an Office of Legal Counsel memo. This doctrine has been well recognized since the dawn of the Republic. The president, quote, cannot be liable to arrest, imprisonment, or detention while he is in the discharge of the duties of his office. Justice Story wrote about that in his commentaries in 1833 because the president is the root of the executive branch. Okay. The system doesn't work if you can do that. It's like dividing by zero. It does not compute. After reviewing historical sources and case law, the DOJ reinforced this conclusion in 2000. They said, quote, the DOJ wrote this, given the potentially momentous political consequences for the nation at stake, there is a fundamental, structural, and incompatibility between the ordinary application of the criminal process and the office of the president. Tell that to Judge Chutkan, who said repeatedly during her prosecution of Trump, it didn't matter at all. The same complete immunity from criminal process of any kind extends to a president-elect. He's transitioning into the president. There is no material difference between President Trump's current status after his overwhelming victory in the national election and that of a sitting president following inauguration. Federal law provides for the orderly transfer of executive powers in connection with the expiration of a term. Specifically, the Transition Act requires all officers of the government to take lawful steps to promote the orderly transition, and the national interest is reliant upon this. Trump has already commenced this process. It's monumental fundamental. To require Trump to address further criminal proceedings at this point would not only violate the Constitution, but it would also disrupt the presidential transition process. And states have no power to retard, impede, or burden anything like that. Saying, in short, the Constitution forbids placing into the hands of a single prosecutor and grand jury the practical ability to impede a president. And so accordingly, Alvin Bragg should dismiss the charges. That's you, Alvin, with prejudice, forthwith. Now, dismissal is also required because Bragg and his office, they have an inability to timely conclude this case in a timely and lawful fashion. The investigation took years. The charges were not filed until after Trump declared he was running for president, and pre-sentencing appeals concerning federal law issues would unacceptably continue long into Trump's second term in office. For example, they tell us last month, Alvin Bragg strategically chose a post-election date of January 13th to file a responsive brief in the Second Circuit. Now, in order to vindicate Trump's rights to a federal forum, which is even stronger after an election, Merchan must not decide the immunity motion or sentencing before the appeal is resolved. Okay, so they said we're appealing another issue, and that has to come first in the sequence of events. If you go out of order, then you violate our right to appeal. The result would be illogical. And so as a result of Bragg's choices, including the decision to bring the charges against Trump after he declared his candidacy and to wait until next year to file, his office is responsible for an inexcusable delay that will result. And if they cause an inexcusable delay, you must dismiss the indictment. Moreover, regardless of the outcome of the appeal, Judge Merchan, if he should deny the pending presidential immunity motion, then Trump's going to appeal that. Now, although Trump may initiate the appeal in the first department in New York, it could ultimately go all the way up to the Supreme Court. And that process would likely take a year or more. And they knew that was going to happen, and it's going to be delayed. And so finally, to state what should be obvious, Judge Merchan cannot impose any restrictions whatsoever on President Trump prior to or during his second term in office. Thus, even if there was to be a sentencing, despite Alvin Bragg's violations of presidential immunity at a grand jury setting and the trial, nothing could take place until late January 2029. And that timing is impermissible under New York law. You cannot delay it that long. Collectively, these issues threaten the possibility of an extended proceeding, which alone may render the president unduly cautious in the discharge of his duty, right? If the president has to worry, I'm going to get out and they're going to throw me in prison as soon as I'm out of office, they're going to arrest me, he's going to be focused on that, not getting arrested, not doing his job. The Constitution does not tolerate impediments to the effective functioning of government. The enfeebling of the president and our government would thereby result, and there would be factional strife, which is exactly what the framers wanted to avoid. And we have avoided it, okay? We have voted and vetoed all of these stupid cases. Nobody cares about them. They voted for them, for the president. Let me say that again. I say that a lot. Nobody cares. A lot of people care, obviously. They're still upset about it. But they lost the election. So we move on past that issue. The game is over. Recognize accordingly, we don't need unnecessary strife. This is another reason that dismissal is required and in the interest of justice. They say a stay is necessary here. The foregoing considerations establish the need for dismissal. However, to the extent that you're unable to dismiss this case before the end of the week, Trump's defense said, we're going to file a motion for a stay of proceedings. While you consider this, while the appeal is resolved, let us know how you want to proceed, Alvin Bragg, right? So this is Trump's defense sending this to Alvin. Now Alvin is responding, and this is what his team has said to the judge. Fresh out of the oven, November 19th, they say, dear judge, here's our position in the New York case. As a result of the election, says Alvin's office, on November 5th, President-elect defendant is the right proper phrase, inauguration as president will occur on January 20th, 2025. In light of that development, President-elect defendant asked the district attorney by letter that we just read to dismiss this prosecution and to consent to a stay of these proceedings pending consideration of his dismissal request. Now, the people requested a brief adjournment to evaluate this. We wanted some more time to think it through, which you granted. And in doing so, you told us to submit this by this date, which we are doing now. Now, for the reasons that we're going to explain below, Alvin Bragg and his office, we believe that the people should set a motion schedule for the forthcoming motion to dismiss, which the people intend to oppose. So when Trump files to dismiss all this, they're going to say nope. Assuming that you allow him to file a motion to dismiss and the court does so promptly, the people ask that their response to keep this case right on track comes back by December 9th. The people believe that further proceedings before this court should be adjourned to permit litigation of the defendant's forthcoming motion, and therefore the people would not oppose a motion for a stay of further proceedings proceedings while the motion is adjudicated. So this is where Trump's team is declaring victory, because it sounds like that sentencing is no longer on the docket. Right now, the next thing that we'll have will be adjudication of a motion to dismiss. See, the sentencing is slowly getting moved, bumped, and replaced. So yeah, we don't oppose a defense motion for a stay of further proceedings before this court, which is currently the sentencing. That is the further proceeding while that motion is adjudicated. All right, so it's very sneaky prosecutor language, but they're like, yeah, sentencing's kind of gone. Now, the people, when they file this motion to dismiss, they say, we're going to oppose this. We've carefully considered what Trump's team has said. They say that this case must be immediately dismissed because of legal immunity as the president-elect and because they're appealing this. And they say, we think those arguments are bad. They say defendant's letter also argues the case should be dismissed now because the appeals cannot be timely concluded and that Trump is immune. They say, well, the people deeply respect the office of the president. Not really. They're mindful of the demands and the obligations of the presidency, and they acknowledge that Trump is president-elect defendant's inauguration will raise unprecedented legal questions. But no current law establishes that a president's temporary immunity from prosecution requires dismissal of a post-trial criminal proceeding that was initiated at the time when he was not immune. So we got him in the window when he wasn't immune, and so that's good enough. Immunity is not retroactive, in other words. Rather, existing law says we must balance these interests and preserve the integrity of the justice system. And so given the need to balance these issues, consideration must be given to non-dismissal options that may address any concerns raised by the pendency of post-trial criminal proceedings, such as deferral of all remaining criminal proceedings until after the end of Trump's term. Okay, we were waiting for that. They'll just pause it. They'll say, sure, yeah, we'll just pause it. We'll come back in 4 years and we'll just pick it right back up. We'll do sentencing right after. Indeed, one corollary of the temporary nature of presidential immunity is that immunity should not lead to consequences that forever thwart the public interest in the law. And so they're going to fully brief those issues, and they're going to want to hang on to this until Trump's done. But they say, we do not intend to object to a stay, though, of further proceedings. Yeah, that's the sentencing. In addition to intending to file a motion to dismiss, president-elect defendant has also expressed his intent to seek a stay of further proceedings. In response to any such motion, the people expect that we would not oppose the request of a stay. We note two reasons. Why are we okay kind of getting rid of the sentencing without saying that? Well, first, as a practical matter, Trump's stated plan is to pursue immediate dismissal and file interlocutory appeals. Those are appeals in the middle that would lead to a stay in any event. So sentencing is going to get postponed anyways. We're also going to stay proceedings now until the resolution to avoid unnecessary litigation. And if we go to sentencing now, it would not avoid the new immunity question that they intend to raise. So he finally said the word sentencing. Okay, first time I think he said it in this time because he doesn't want to admit what they're alleviating. You can see it in his writing. Further proceedings, further proceedings, further proceedings. We're okay moving further proceedings, remaining criminal proceedings. It's a sentencing. You know what it is. Say it. I know it hurts to say it. I know you don't want to admit it, but you have to. And they finally did at the very end of the motion. You're postponing this sentencing. These aren't pretrial proceedings. Signed by Alvin Bragg himself and Matthew Colangelo, Biden's hitman, hatchet man, the original number 3 in the DOJ, who left. Guess who he's going to be replaced by? Emil Bove. Yeah, baby. Incredible. So life just is getting better and better, as you can see. And now we'll come back on the 26th, or we'll see if the docket is updated. But Trump's people very happy about it because they're recognizing what that actually said. Alvin Bragg is admitting sentencing doesn't need to happen now. We're going to go backwards, basically, and now open this case for litigation on a motion to dismiss. So Trump wins again. Alvin Bragg and the corrupt DOJ prosecutors who were sent over there, like Matthew Colangelo, to help Alvin Bragg and his office there in Manhattan, lose again.